Okay, folks, welcome. We're going to go ahead and get started, and I'm sure we'll have more folks trickle in. My name, for those of you I haven't met, is Alex Budd. I'm the Alliance organizer for the Pacific Northwest Forest Climate Alliance, which is a regional network of forest and climate grassroots organizations across the Pacific Northwest, working at that intersection on a whole host of issues. And we're excited to be hosting this webinar today. This is the third in our series this summer about federal assaults on our forests. There's been so many changes happening judicially with Supreme Court decisions and in Congress and certainly the executive branch that it can be really hard to track them all. So this series is an effort to try and break those things down for what they actually mean for us on the ground and what we can do about them. I'll put in the chat the links to the last two that we did, one in June or at the beginning of July on the Fix Our Forest Act and Trump's budget bill, and then one at the end of July on executive branch actions. If anyone wants to watch those recordings, if you've missed one of those. Today, we're going to be talking about recent Supreme Court decisions and what those mean for public and federal forest lands, as well as the rescission of the Roadless Rule, which I'm sure folks have heard about. And just today, the press release came out that the comment period is going to be opening up on Friday. So it's going to be very short, and Chandra will talk more about that, but definitely a time to rally everyone we can to speak out. We're going to be hearing from Brenna Bell with Crag Law Center and Chandra LeGue, Senior Conservation Advocate at Oregon Wild. And just housekeeping, if folks have questions, feel free to just drop them in the chat and we'll address them in real time if we can, but we're also planning to save some more time at the end for questions because we know this stuff can be complicated, especially legal decisions from the Supreme Court tend to be very wonky. So want to make sure we have some time to talk about that. Yeah, I think that's it. Anything else, Brenna or Chandra, before I hand it off to you, Brenna, to kick us off?
I'll just say that the way my screen is set up, I will not be able to see people's questions. So if you need to interrupt me, please do.
Great.
Then with that, hi everyone, my name is Brenna Bell. I am on the steering committee for the Pacific Northwest Forest Climate Alliance. I was recently working with 350 PDX, but I'm now going back to my roots as an environmental attorney, and I'm a senior staff attorney with the Crag Law Center. And for those of you who don't know, Crag Law Center provides free legal services to environmental nonprofits throughout the region to help with the legal aspects of their campaigns. And it was kind of fun to be able to be in this webinar series, putting my lawyer hat back on. The last one I talked about executive actions, and today I'm going to spend a little bit of time talking about the judiciary. But before I dive into a couple of recent Supreme Court decisions, I just want to give us some context about the judicial branch, right? They're the ones that interpret the law. And the basic structure is that there are 94 district courts throughout the country, and this is where all federal cases originate. And the number of districts in a state depends on how the population is. So in Oregon, we only have one district. In Washington, there's two. In California, there's like five. And so if you don't like your decision at district court, you get to appeal it to the Court of Appeals. And there are 13 different circuit courts of appeals throughout the country. Again, they're geographically oriented. We're in the Ninth Circuit here in the West. And in the circuit court, when you're appealing, they have to hear everything, right? But if you don't like your circuit court opinion, the next step is the Supreme Court. And there's one Supreme Court, 9 judges, and unlike the lower courts, they get to choose which cases they hear. So they typically choose cases if there is a conflict in the circuits or if there's a particular legal issue that they're really eager to resolve. So all federal judges are appointed by the executive branch and confirmed by the Senate. And then once approved, they hold that position until they either retire or expire. And over the last couple of decades, approval has become extremely partisan. Just for example, in 1993, Ruth Bader Ginsburg was approved 96-3, right? Her replacement, Amy Coney Barrett, was just approved 52-48, almost exclusively along party lines. So there's been just like a sea change in how the Supreme Court has been functioning. You know, it long held a lot of respect and bipartisan support. This is also in decline. As of July 21st, a Gallup poll found that 56% of respondents did not approve of the way the Supreme Court was handling its job. And this is a near historic low. It peaked at 58% in 2022. So in this political context, it is not surprising that the current Supreme Court, with 6 conservatives and 3 liberals, is issuing some very sharply divided opinions. And even if they agree on outcomes, like we'll talk about in the 7 counties case, their reasoning can be very different, leading to multiple opinions on the same issue. I'm just going to focus on 2 recent cases that were pretty big and impact federal management of public land and the environment. And that's Loper Bright Enterprises versus Raimondo, which overturned Chevron deference, and the 7 county infrastructure coalition v. Eagle County, which took a big swipe at the National Environmental Policy Act, or NEPA. And this may get a little legally wonky, but bear with me and I'll try and make sure everything's well explained, and happy to do questions afterwards. We're going to start with Loper Bright and the issue of deference to federal agencies. So before we can get to Loper Bright, we have to go back to what is Chevron deference? In 1984, the Supreme Court decided the case Chevron USA versus Natural Resources Defense Council, and it set forth this legal test for courts to use to determine the meaning of a law or a statute. So the Supreme Court found that if the statute is ambiguous and Congress has not spoken directly to the issue at question, the court must defer to the expert agency's interpretation, so long as that interpretation is based on a permissible construction of the statute. So in the original case, a unanimous court ruled that the ambiguous meaning of the term source in the Clean Air Act meant that Congress had delegated to the EPA the power to make a policy decision and define the meaning of source. In its decision, the court emphasized that the US judiciary is not a political branch of the government and that US federal judges are not elected officials. So it is not the place of the court to interpret the Clean Air Act and set government policy on the regulation of air pollution emissions. This ended up becoming one of the most important decisions in the realm of administrative law, which is like the law that governs federal regulatory bodies. While it was definitely still possible to argue that the government's interpretation of a law was an unreasonable construction of a statute, didn't fit with congressional intent, Chevron deference created a much heavier lift for people challenging these interpretations. And I mean, as you can imagine, this is kind of both good or bad, depending on whether or not you like what the government is doing. But there's many judges who did not like this, as they said that the courts, not the agencies, should be the final arbiter of the meaning of the law. And it also became a really political issue for people who were opposed to the administrative state, who wanted less power in federal agencies. So eventually, enough judges who took issue with Chevron got on the Supreme Court to deal with it head on. Like for years, court opinions have been chewing around the edges of Chevron, but finally they got to the point where they had a solid majority and were like, we're ready to take this up head on. So enter Loper Bright Enterprises v. Raimondo. I'm not really going to talk about the facts of the case because they actually didn't really matter. The judges just wanted a case in which they could directly take on Chevron. That's what they did. And a 6-3 majority overruled the principle of Chevron deference. And the majority opinion was written by the Chief Justice, John Roberts, and he said that, quote, under the Administrative Procedures Act, it remains the responsibility of the court to decide whether the law means what the agency says. So it just shifted back from this immediate deference to the expert agency to say, no. We will look de novo, at first look, at these regulations and determine, us, the courts, what the meaning is. So Justice Roberts continued that, quote, Congress expects courts to handle technical statutory questions, and that the judicial venue allows them to get assistance and additional input from interested parties via amicus briefs. So in lieu of Chevron deference, this Loper Bright decision assigns the determination of congressional ambiguity to the judicial branch, while executive agency expertise is still to be considered, but under a much weaker deference standard established in the 1940s in a case called Skidmore v. Swift. So that was kind of a sea change law. 40 years later, a big shift in administrative law. And now the question, though, it's like, so what, right? Like, what's the impact of Loper Bright? And first, I'll say a couple of things that it did not do, or the limitations on it. So importantly, this decision only removed judicial deference to an agency's interpretation of law, not the actions they take or that they fail to take or their determination of fact. These still receive a deferential standard of review, as we will discuss in a few minutes in the NEPA case. Also, the existing rules and case law that were already decided under Chevron deference remain in place, right? This didn't undo anything that had already been decided. It just set the standard for moving forward with agency interpretation of law or statute. So while it doesn't invalidate any existing rules, and legal nerds pay attention to this, there's another recent case called Corner Post that the Supreme Court did. And in Corner Post, they got rid of any statute of limitations for challenging agency actions. It used to be like after an agency rule was written, you had 6 years in which to challenge it. And if it wasn't challenged within that, it just became set. Well, Corner Post just got rid of that. Basically says if you are newly impacted by an agency rule, you can challenge it at any time. So while Loper Bright didn't undo any Chevron cases, Corner Post basically said all regulations can conceivably be challenged under this new statute. So there might be, I mean, there's already a lot of problems going on in the government, but this creates even more instability where set rules might be able to be challenged under this new non-deferential statute or standard, and we'll see what happens. Okay, so those are the limitations. But even with those limitations, there was a really big reaction to this decision, right? Most people heard about it. Everyone was like, oh, what does this mean? Chevron deference. Well, many people saw this decision as a culmination of the current Supreme Court's efforts to weaken the administrative state, right? As part of this larger conservative agenda against big government. It was widely criticized by environmental groups. The Southern Environmental Law Center issued a statement saying that the ruling, quote, shifts power to judges who do not have the expertise of the agency staff who live and breathe the science, financial principles, and safety concerns that federal agencies specialize in, right? So there's this big pushback. And I have to say, I think that there's some nuance here. I don't think that this is an all bad decision, right? In the original Chevron case, it was NRDC who was challenging an EPA rule that weakened air pollution standards. Remember, this was 1984, and the Reagan administration was undoing a lot of protections of the Carter era. So the less protective definition of source is what the Supreme Court deferred to. And we're again in a time when federal agencies are not making regulations or statutory interpretations based on science or safety concerns or reality, and the lack of deference may actually level the playing field a bit in court. So perhaps my feelings about Loper Bright are best summed up by Judge Gorsuch in his concurrence to the opinion, where he wrote that the only change in administrative law going forward is that federal courts, quote, should resolve cases and controversies without any systemic bias in the government's favor. Fairly put, I think. As someone who has often sued the federal government, I see both the challenges and the opportunities created by removing Chevron deference. That said, it was a big deal, but most cases don't actually hinge on the agency's definition of a statute or regulation. Most of the cases we do are about the agency's interpretation of fact and their action, right? And that's what we'll look at in the next case I'm talking about, the 7 counties case with NEPA. And while I feel kind of, ambivalent about Loper Bright, 7 County Infrastructure Coalition v. Eagle County, which is a Brett Kavanaugh decision from this May, was just pretty rough. Although again, it's not quite as bad as some people are making it out to be. So let me take some water and I'll tell you about 7 County. Okay. Before jumping into this opinion, we're going to do a really quick NEPA refresher. Just so everyone's on the same page what we're talking about. The National Environmental Policy Act was passed in 1970, and it's been called the Basic Federal Charter for the Environment. And while NEPA does not itself require specific actions to protect the environment, it directs the government to evaluate and disclose the impacts of major federal actions and ensures that the public can comment on these actions before a decision is made. Even Kavanaugh's opinion highlighted this foundational aspect of NEPA, saying, quote, NEPA ensures that the agency and the public are aware of the environmental consequences of proposed projects. Properly applied, NEPA helps agencies to make better decisions and to ensure good project management. So not totally bad, but definitely not good. So there are several things going on in 7 County that I want to highlight. One is the actual legal decision. 2 is the dicta, or all the words in the case that are not directly tied to the holding, but Justice Kavanaugh just felt like he had to say. And 3 is the emphasis on deference to federal agency action. So first, which is kind of like the most legally important, but actually a minor part, turns out, of this opinion, is the actual holding, right? Like what actually was going on in the case and what judges decided on the law. So in 7 County, the project at question was an 88-mile railroad that was proposed specifically to transport oil from Utah to be refined in Texas. And the plaintiffs said that the NEPA analysis of the railroad should have included the impacts from both drilling the oil in Utah and then refining the oil in Texas, and not just the railroad itself, as those were reasonably foreseeable impacts stemming directly from this project. Now, the Supreme Court issued a unanimous opinion that these impacts were not a part of the specific proposed action, and also outside of the scope of the decision-making body, which this was the Surface Transportation Board, and therefore did not need to be included in the NEPA analysis. And if that was all the court did, it would kind of be an unremarkable decision. It was a limiting but understandable interpretation of NEPA and what NEPA meant by analyzing the project. Like, right, where's the bright line that you draw around what is a project and what's not? What do agencies or decision makers have control over and what do they not? And in fact, this is what the concurrence opinion of the 3 liberal judges did, right? They agreed with the final holding, but they did not agree with the majority's approach to the holding. So that's what a concurrence is, like a kind of pop-out decision when a judge wants to emphasize something different than the majority. The problem is the majority's opinion, where Justice Kavanaugh just goes off about NEPA. And this is that dicta part that is the real problem of this case. So the opinion just complains a lot about NEPA, complains about it getting in the way of new infrastructure. It's in like, I can just imagine Judge Kavanaugh whining about it, being like, but I wanted to build those things and I didn't get to build those things because of NEPA. You can imagine his affect and vibe. So yeah, he whines about NEPA and then also downplays the environmental values inherent in the statute, right? The opinion keeps stressing that NEPA is purely a procedural statute and that the agency's only obligation is to prepare an adequate report. And the adequacy of EIS is relevant only to the question of whether an agency's final decision was reasonably explained. One of the great quotes, he says, importantly, NEPA does not require the agency to weigh environmental consequences in any particular way. Simply stated, NEPA is a procedural cross-check, not a substantive roadblock. The goal of the law is to inform an agency decision-making, not paralyze it. And Kavanaugh's dicta, it's annoying, but it's also straight up wrong. Like, NEPA is an environmental statute. As its preamble says, the purposes of this act are to declare a national policy which will encourage productive and enjoyable harmony between man and his environment, to promote efforts which will prevent or eliminate damage to the environment and the biosphere, and stimulate the health and welfare of man. This does not sound like Congress intended it to be just a, quote, procedural cross-check. So the dicta's bad about NEPA kind of being devalued from any environmental purpose. And then there's the question of deference, right? So where Loper Bright reduces judicial deference to agencies' interpretation of law, Seven County reinforces strong deference to agency factual and technical judgments under NEPA. I mean, from start to finish in this whole opinion, the court just emphasized that the central principle of judicial review in NEPA cases is deference. Yeah, and they say under that standard, a court asks not whether it agrees with an agency decision, but rather only whether the agency action was reasonable and reasonably explained. So again, Loper Bright held that courts must independently interpret statutes without deferring to agency holdings, and that decision invites a more aggressive judicial review on questions of agency authority. But in contrast, Seven County made it clear that deference remains intact when reviewing an agency's fact-intensive approach to something like an environmental analysis under NEPA. The opinion said that courts should not micromanage such technical judgments so long as they are reasonable. So taken together, these two cases result in a clearer divide about deference, right? Post Loper Bright, courts will more actively police agencies' interpretations of law, but they still must defer to an agency when reviewing the scope and adequacy of agency action, unless it is arbitrary, capricious, and not in accordance with law. So, how bad is Seven County? Or can NEPA lawsuits still exist? And yeah, it's bad, but it's not that bad. While the actual holding, right, that little law bit up at the top, limited the amount of reasonably foreseeable impacts that a NEPA analysis must address, the opinion recognizes that NEPA itself still requires analysis of direct, indirect, and cumulative impacts of the project itself. That is unchanged. And the court also restates that NEPA's procedural mandate helps, quote, to ensure a fully informed and well-considered decision, and thus affirms the statute's fundamental purpose. And for all its talk about deference, the opinion doesn't actually create any new approach to deference. All NEPA litigation was already operating under the APA's arbitrary and capricious standard. Like, that's unchanged. The opinion just really wanted to emphasize how deferential this standard is. And all that said, this case does pose a problem for NEPA litigation. Like, anyone who works in the realm of NEPA, watchdogging, analysis, litigation, and public lands is going to have a lot to contend with in the future, because it really de-emphasizes the role of the courts in holding agencies accountable and following NEPA. One of those great dicta quotes is, quote, Congress did not design NEPA for judges to hamstring new infrastructure and construction projects. On the contrary, as this court had stressed, courts should and must defer to the informed discretion of the responsible federal agencies. Also, quote, all of that is to underscore that a difference may exist between what an agency should do as a matter of good policy and best practices under NEPA and what a reviewing court may subsequently order an agency to do under NEPA. So again, it's setting up this sense like, yeah, the agency didn't do the right thing or even the best thing under NEPA, but like, is it good enough? Well, if it's good enough, then the court just has to defer to the agency. And it goes one step further in the issue of what we call remedy, right? So if you have a lawsuit and you win, there's still this question of like, well, what's the remedy? Like, okay, we figured out that this agency didn't follow NEPA. Well, then what needs to happen? And what this court says is it explicitly references what's called harmless error. Like, yes, they violated NEPA, but was it really so bad? And they suggest that a NEPA violation is not necessarily grounds to vacate an agency decision, quote, at least absent a reason to believe that the agency might disprove the project if it added more to the EIS. So they basically say, unless you can show that the agency would have made a different decision or disprove the project because they did NEPA better, then there might not be any reason to vacate the opinion. So you might win in court, like they might say, yes, they violated NEPA, but we're not going to overturn their decision because we can't show that following NEPA correctly would have led to a different result. And that is a problem, right? That is going to create challenges in stopping projects, even if the court agrees that they violated NEPA. So I think moving forward, we're going to find people like myself and other environmental attorneys are going to be a lot less keen on bringing litigation that just has NEPA claims, that doesn't also have like violations of substantive claims, like the National Forest Management Act or the Endangered Species Act, because of this issue of remedy and vacatur. And I just need to note almost done, but I want to wrap up and say that this bit is totally dicta because he didn't need to say that at all because they actually found that there was no violation of NEPA. So again, Judge Kavanaugh just took this one central issue, which was like kind of an understandable decision and just puffed it up and just went full on against NEPA in a lot of non-binding decisions, but like non-binding language, but it's the Supreme Court. And so it's going to have an impact on the courts. And we're already seeing that, right? We're already seeing the government citing this case everywhere. One of my colleagues just got a government brief that cited 7 County on almost every single page of the brief defending a timber sale that the BLM is doing. And we're seeing courts starting to cite this case. So the best case scenario, right, is that a good judge or a good panel is going to really narrow 7 County back to its actual legal holding. It's going to say, oh, look, a lot of this is just fluff words. It's just dicta, non-binding, doesn't have anything to do with the holding. We're just going to narrow 7 County down to its discussion of reasonably foreseeable impacts and acknowledge that the rest of it is not mandatory to follow. That's the best case scenario. The worst case scenario is it's just like a snowball that picks up weight and more courts are going to start citing it. And then there's just going to be a big vibes push against making solid NEPA decisions in court. So with all that, I want to leave with you knowing that NEPA, the statute, is still the law of the land, and that this opinion, even when casting a pall on NEPA, still recognizes that the central purpose is to, quote, help agencies make better decisions and ensure good project management. And that's what we're trying to do too. and NEPA is still a good tool in our toolbox. So with that, I'll stop and pass it over to Chandra to talk about the roadless rule.
We did have one question, real quick, that came up from Terry in the chat, Brenna, for you, which is, in medical lawsuits, judges have always been able to defer to whoever brought the best expert witness. Does this not apply at all anymore to NEPA? If we bring better experts, we win? Question mark.
That's a great question. Typically, NEPA decisions are based on the record that was before the agency when it's made its decision. So witnesses play a really, really different role. We don't have experts in the same way in administrative law. It's just like what was in front of the agency. What you can do, though, and what we encourage everyone to do is, while we still can get public information in front of the agency, right? Like in the last webinar, we talked about how the regulatory changes are making that harder. But like in public comment, get your expert testimony in then, because then it's in the record that will be in front of the agency when they make their decision. And that's what the judges look to. It's not going to come up later in the court proceeding like in a medical case might. So experts are still important because then we can be like, look, their decision is completely bonkers based on the actual facts, like based on what the experts say. And that's what engages that like arbitrary, capricious, and not in accordance with law standard. So get your experts in, but get them in early, so they're in front of the agency when it's making its decision.
Thanks, Brenna. There's another question in the chat that if you want to just type out an answer to, so we can make sure that there's enough time to get into the roadless rule, Ms. Chandra.
Okay, yeah, I know. Like, it's a lot to digest. So I'm like, the questions might be slow to trickle in, but yeah, hopefully we can get to more, or you can do them in the chat. Just when you think an hour is plenty of time for a webinar, right? Well, thanks everyone, and thanks Brenna, that not having gone to law school and only partially following all of that, like, wow, very important. All right, well, everyone, I'm Chandra LeGue. I'm with the Oregon Wild, and I'm going to talk with you about the roadless rule. And I actually have pictures. So I'm gonna get that all set up here. Hopefully this works and I can see all the things that I need to see. Are you guys seeing this picture? Okay, great. Well, there's news today, which I'll get to in a moment, but we're talking about defending the roadless rule. And I'm going to start by kind of talking about what the heck are roadless areas and why are we talking about the roadless rule? And you know, this is an important first question. So what's a roadless area? I mean, they're kind of defined by what they don't have, which is roads. But for the purposes of what we're talking about today, these are largely undeveloped, unlogged, unroaded, wild landscapes that are found on U.S. Forest Service lands across the United States. You know, we don't see roadless areas on most of the maps that we use to go hiking or pick a backpacking trip. We see wilderness areas on the maps, but we don't see roadless areas. It's because they're not congressionally designated. And I'll get into that in a moment. And then if you haven't heard about roadless areas or over the last a couple of decades, it's probably because we haven't, as environmentalists, really been worried about them since 2001 when the roadless rule was put in place. They've been kind of put into this new bucket of protected areas that we don't have to fight over. That was pretty sweet. Now we have to fight over them again. And so that's why we're talking about roadless areas and the roadless rule now. So I do want to then next step is how did we get here to even be talking about these areas as special? And I think the key thing is to look back at the context of our national forest lands and what we've done on them over the last century. Starting in the 1960s or so, we started really extensively adding roads and clear cuts and other developments to our national forests. As you can see in this picture that popped up, there is a boundary line showing the Three Sisters Wilderness area and then the rest of the Willamette National Forest outside of that big bold line. And outside of the protected wilderness areas that have been added since the 1960s, you can see extensive clear cutting and other logging and roads crisscrossing our national forests. And in addition to things like the Wilderness Act and the Endangered Species Act that have allowed conservationists to add some protections for wild places and wildlife habitat, there also have been forest plans put in place over the last few decades that have sort of delineated where you can do certain things like more logging and road building, but that didn't actually keep the national forest from doing these activities. So roadless areas are pretty rare on the landscape, and here's another illustration of that. I know this is for the Pacific Northwest, but I'm focused in Oregon, working for Oregon Wild. So some of my examples are pretty Oregon centric, but similar concepts apply. So in Oregon, we have about 220,000 miles of roads. Many of those were built for logging. And you can see, in our developed areas around, cities, Portland, Eugene, Bend, they're pretty black because of the high density of roads. And but you can also pretty clearly see where the roads aren't. And those are in wilderness and roadless areas, essentially. Because roads were largely built for logging outside of our communities, logging comes with its own speed of impacts, but the actual impacts of roads themselves are pretty huge. It fragments wildlife habitat, makes it harder for wildlife to move around. They block fish passage. They introduce and spread invasive weeds. They contribute erosion into streams. So having all these roads in the landscape, has major impacts. And again, it makes areas where there aren't any roads all the more special. That specialness was recognized even going back pretty far. So in the 70s, the Forest Service started to inventory and map large undeveloped roadless areas in a process called RARE, which was the Roadless Area Review and Evaluation. They actually did it twice because the first time they didn't do a very good job. And so RARE 2 became the final process that was finalized in 1979. And I found this old Oregon Wild newsletter from 1978 when that process was going on, and the public was weighing in. So this was one of those things back when we had a robust NEPA process and public participation. People were definitely getting involved and trying to keep the Forest Service honest and actually identify and inventory all of the big undeveloped road areas on the national forests. The RARE 2 didn't actually end up doing that. They did leave out some of these areas that people identified and tried to get put into the final inventory. So just this kind of a side note about that. Since RARE 2 in the late 70s, some of those big roadless areas have been protected as wilderness, but many have not. And the RARE 2 inventory actually didn't protect these areas. They just identified them. So when the Clinton administration was doing a whole bunch of stuff, including the Northwest Forest Plan, but other environmental actions, they directed the Forest Service to actually come up with a rule to protect the inventoried roadless areas. And that is what culminated in the Roadless Area Conservation Rule, what we call the Roadless Rule in 2001. So in the end, what the Roadless Rule does is, well, first of all, it applies to national forest lands. I've mentioned that, but not to BLM lands or state lands. So just to make sure that everyone's on the same page there. And across the US, it includes 50.5 million acres in 38 states and Puerto Rico. So 39 states and territories. So that's a lot of acres. In essence, it keeps wild places wild. It keeps the roads out of those areas without roads. And so they could be protected in the future as wilderness or in some other way under a forest plan. The rule prohibits new road building and reconstruction of roads in these areas with some exceptions. There's always exceptions. It also prohibits commercial logging with some exceptions. Those exceptions for both are largely based on public safety, but and the language does say that commercial timber cutting is expected to be infrequent. So it's pretty strong, but there's definitely wiggle room. And then I'll also say importantly that the Roadless Rule does not prohibit things like machinery, like chainsaws, mountain bikes, off-road vehicles, snowmobiles. It does not have that same those same prohibitions like wilderness areas do. So still a lot of things that are allowed in roadless areas, but generally protects them from new road building and commercial logging. The process to develop the rule is pretty extensive. It took place over about 18 months. There were 600 public meetings. And overall from the public, of people who care about public lands were involved. And I'm not just talking about environmentalists who love to hike. It was also hunters and anglers and people who run outdoor businesses who saw the value in these places, not just, you know, sort of in the classic wilderness sense, but as parts of our economy. Whether you agree with that or not, but it was definitely one of the reasons why this rule was so popular is because there was the backing of those sorts of groups. Of course, this rule was challenged almost immediately. The Bush administration came in right after Clinton and tried to move to a state-by-state roadless rule. That was kind of his way of getting rid of it. It was like, oh, each state can petition to have their own. Environmentalists challenged this and went back and forth. In the meantime, there was actually some of the only logging in roadless areas that have happened since the rule was put in place happened in Southern Oregon during this legal limbo time that was in the Biscuit Fire area outside of the Kalmiopsis Wilderness. And our governor in Oregon, you know, stood up against Bush's idea of doing our own roadless rule, and eventually, you know, we prevailed, and the roadless rule became, you know, remained a national rule and not divvied up. In the meantime, Colorado and Idaho actually did develop their own roadless rule, and those stand today. And I'll get back to that in just a minute. And then in 2020, during the first Trump administration, they worked to exempt the Tongass National Forest in Alaska from the rule. Biden put it back. So this fun ping pong. And then, of course, last month, the administration announced its intent to rescind the roadless rule. And that's where there's news today, because we actually have that official notice coming out on Friday. I do want to go back for a second on, you know, these actual places that are at risk. Like I said, you know, we see wilderness areas on maps, national parks on maps. And on this map, you can see those in dark green. It's something that's pretty common. The light green are all our national forests. But all the blue on this map are the roadless areas that were inventoried and included in the roadless rule. And in Oregon, that's about 2 million acres. I think it's actually fairly comparable in Washington. I don't have that number, I'm sorry. And some of them are surrounding protected wilderness areas. Some of them stand on their own. And just a few quick examples of places. Tamanoas Falls, if you've been there, it's on and is part of a roadless area adjacent to, kind of spilling out from the canyon in Northeast Oregon has headwaters to the Grand Ronde River. It's the Nez Perce tribal homelands and is in wildlife connections. Iron Mountain is a part of a big roadless area in the Western Cascades, known for its biodiversity and wildflowers. Lookout Mountain in the heart of the Ochiko Mountains, right in the middle of Oregon. 14 River Canyon. Now here is a wild and scenic river, and just, you know, surrounded by giant ponderosa pines, and there's about a 7,300 acre roadless area around that. And then in southwestern Oregon, you see a lot of blue around the big green spot here. That's the Kalmiopsis Wilderness, and huge roadless areas that surround it, really making that the largest expanse of, you know, wild landscape in Oregon. And Rough and Ready Creek is an example of an amazing geologic, wonderland. And it's threatened not only by mining, but by logging, but also mining. And I'm just going to click on the, tell me if this works, where this goes to another map, or if you can see.
We can see it.
Or if you can just still. Okay, great. So we'll put this in the chat or send it as a resource, but there's a number of good maps out there that are interactive, that show roadless areas around the country. So I know I'm just talking about Oregon and some examples, but you can use a map like this to check out roadless areas in Washington and Montana and California, which is a fun tool for finding places that you might know. Okay, back. Okay, so what's happening now? And I know we're running out of time. Lots of actions that we've been talking about on these webinars to the Forest Climate Alliance that you've been keeping up with. And the Roadless Rule repeal is just one of these things, part of the evil master plan of the Trump administration and everyone that supports this stuff. So in June, Secretary Rollins, the USDA Secretary, announced they were planning to repeal the rule. Today, the word actually came out that the official notice is happening Friday, and we will have a 21-day comment period for the public to weigh in. This rescission does not apply to Colorado and Idaho because they have their own roadless rules. I just want to make that clear. And also make clear, like, what happens if the roadless rule goes away? Well, these are national forest lands, just like any other, that are subject to the forest management plans. So in Western Oregon and Washington, the Northwest Forest Plan and the underlying forest plans would take over. And we know that plan is being amended, or we'll see how that moves forward, and could allow more logging in older forests, for example. In Eastern Oregon, the Blue Mountains forest plans are being revised and could allow logging of larger trees. And so if the protections of the roadless rule aren't in place for places like Lookout Mountain, perhaps those old forests would be open to commercial logging. But, with all these other actions, the mandates for increased logging or timber production from federal lands, there's other executive orders on increasing mining and energy development from our national forest lands. All of that stuff that we've been talking, these court decisions, right? All of this could mean these places could be opened up. We could see more roads and all the related impacts, more logging and mining, more fragmentation of wildlife habitat, cutting down our carbon storing forests, and more fire starts. The more roads you have into these landscapes, the more likely that your humans are going to cause fires. It's about like 4 times more likely, is what studies have been showing. Bad news. But we can do something about it. we are taking steps, all of us, to educate our communities about the fact that these places exist, they're special, and we need to continue to protect them. So, sharing resources onward is great. So please do that. Writing letters to the editor, sharing on social media, all that stuff that's in toolkits that we'll be sharing around. There's a national roadless defense coalition that's developing all these tools, as well as many groups probably present here and working together on getting comments now that the comment period is starting. So we now know that the comment period ends on September 19th. And even though, show of hands, who thinks the Trump administration is going to listen to us when we submit comments? Probably they are going to move forward with this repeal, regardless of what the public outpouring says. But that doesn't mean we shouldn't get our comments on the record. It's really important to build the record so that we can show public support for the roadless rule or roadless area protections. In other matters, this is going to be fought tooth and nail because it is so important. And there's many groups out there collecting petitions and comments, and we'll, share all that so you can do it with those groups, or we'll get out a toolkit so that you can write your own comments. At the same time, we could also pass a law. There's a law floating out there in Congress that they could pass to codify the roadless rules protections. Even though it has loopholes that could use closing, that might be something that people want to pursue. But right now, the Roadless Area Conservation Act is just straight up make the roadless rule protections law so that a new administration can't take it away so easily. Many of the Pacific Northwest representatives and senators have already signed on in support of this bill. If you're in Washington, Senator Murray is on board. Both of Oregon and California senators are on board. A number of Washington and Oregon congressional reps have supported this bill, though Representative Hoyle and Bynum still need some work. So there's an opportunity to reach out to them and urge them to support it. And I think this is one of my last slides. I really want to encourage folks out there, if you've been to one of these areas, explore the interactive maps, look back through your photos and compare them, see, oh yeah, I've been hiking in this area, or I had a fun camp out and explored this area. This is a group of Great Old Broads for Wilderness that's on a hike in one of the roadless areas that are in our neck of the woods. Include those things, stories about places, names of places, maybe even photos in your comments, especially if you're writing a letter to the editor or sending something to your congressperson. We need to make sure that people understand that these are real places with real important values, and you can be a part of that. So encourage folks to do that. And there are a number of upcoming events, and again, this is coming from like what I know just off the top of my head, working at Oregon Wild. We have a couple of hikes into roadless areas coming up, one on Mount Hood and one near Bend. And you can find those on our website. Great Old Broads for Wilderness is hosting a similar webinar to this on Wednesday next week. Oregon Wild's hosting one on September 10th. I know the Sierra Club just did one yesterday. So there's lots of webinars and information being shared. In Bend, I know there's a coalition of groups hosting an in-person comment writing workshop at Worthy Brewing on September 9th. And we're working on one in Eugene, and I'm not sure about Portland, but maybe. And all this is stuff that will, that Alex will send out and share. And then there's also, I guess this is after the comment period, but I know there's been some talk of doing something around Public Lands Day, which is later in September. So that is all I've got. And I saw activity in the chat, but I don't know if it was pertaining to what I was talking about or not. So I'll stop sharing and then let Alex get to that. Thanks.
Thanks so much, Chandra. That was great. Yeah, there was one question about, is it helpful to send comments to members of Congress, which I think you kind of covered. I mean, it can't hurt to make more noise, I think, as a general rule. Everywhere we can be loud. Anyone have other questions? I know we thought an hour would be plenty of time to cover all of this, and it's actually a lot to try and pack in. So thanks everyone for sticking with us for the full hour. Yeah, any other questions folks want to throw out before we wrap up? Things you're wondering about?
And I'm sorry that we don't yet have like the address or link to where you can comment on the roadless rule. That will not be known until tomorrow. And so it's kind of a like the period will start on Friday. We'll have the like link and things tomorrow, but as of right now is just stay tuned.
Terry?
Terry, I just wanted to clarify, not just any comments, but I got into the habit of anytime I write a comment letter and submit it online to the register, I also send it to my federal representatives. Is that like, do you think they read it, or am I wasting my time?
In fact, I think it might be more helpful to send you. I agree, like write the public comment, that goes on the record in support of the roadless rule, and copy it to your representatives, and it might actually have more impact in there. So I would do both. And it could be the same comment, honestly, and you can even adapt your comment into a letter to the editor. And that's the sort of stuff that I think will be in the toolkit that gets sent around, is just how easy that can be.
Sunny?
I have two questions. Since protecting these areas is a really national interest, do we have avenues where we're asking everyone in the country to weigh in? Because, realistically, there's going to be a small handful of people who actually write letters. And it just seems like in every issue we're talking about, it's big. It's bigger than just us. It's bigger than just the Northwest. There's so many reasons for everyone in the country, no matter where they live, to protect these forests. So that's one just urgent frustration feeling. I don't know what to do about it. But the other thing is, on a smaller level, if we write letters saying, "Oh, I love to hike there. I've gone camping there," and so on, is that sort of undermining our position that these forests should not be impacted by humans?
I mean, that's a fair point. But if your argument is you don't want to see them impacted by humans, then I think that's an issue. But if what we're trying to say is we don't want to see new roads, really impactful roads, and commercial logging in these areas, then I think that's something different. And that's what the roadless rule does. So that's kind of what we're defending.
No, I get it. I'm worried about that that backpacker that is not wise about campfires and so on. I would like those not to be welcomed.
Yeah. Right.
Thank you, Chandra. That was great.
And there is, and Carol put this in the chat. Sierra Club is making this a top national campaign. Several other large national groups are making it a top campaign, and there's a large national coalition
Thank you.
that's working on this as well. So we just were trying to keep it focused for our PNW Forest Climate Alliance.
Darlene, did you have a question?
I did. Now I don't remember it. I moved on.
Folks, unfortunately, I do have to pop off. I have another meeting about litigation under NEPA. Wish me luck. But
Brenna.
thank you, everyone. It's always good to see you. So I've got to pop up. If you have any questions for me, my email is just brenna@crag.org.
Thank you, Brenna. Thanks, Chandra.
Anyone else have any other questions before we wrap up for today? Feel free to you can email me questions as well. So if you think of something later as you're trying to fall asleep, then we'll get them to Brenna and Chandra and get answers back.
Thanks, everyone.
Thank you.
Wrap it up then. Thanks, y'all.